Good afternoon, good afternoon, good afternoon, law nerds. All right, we're going to court. We're going to court in Massachusetts. Why? Well, because we have to deal with the Trooper Proctor Discovery. Some of you were around this morning when we tried, and well, we tried. So we are back. We are going to court to see what's going on with the federal discovery for Trooper Proctor. We were in court on Tuesday. We are back in court Thursday. The Commonwealth is in quite a pickle because the Commonwealth has this unusual position of having federal discovery related to Trooper Proctor that was turned over in the Karen Reed case. But then the feds were like, you can only use this in the Reed case, but the prosecutors are aware that it exists. Some of them haven't seen it, but Attorney McLaughlin has, and Attorney McLaughlin is on some of the cases that are in court to deal with the federal discovery because all the defense attorneys are like, excuse me, yo, this is the lead investigator. This applies to us too. Can we get some discovery? And the Commonwealth is like, we would love to tell you that. But there's a federal protective order. So we know that it exists, but we can't give it to you. But it's there, but we can't give it to you. So, Your Honor, can you help? And the feds are like, there's not much that we can do. So we are in this strange conundrum of what is going on with Trooper Proctor and what are we going to do about it? So we're going to go to court. We have, it seems, no cameras in the courtroom, but a Zoom feed. So we're going to grab that. And we're going to see. Gloria in the chat said, not the Commonwealth playing games again. I actually think in this moment, the Commonwealth has said, we have this discovery, but we have a federal protective order and we can't violate a court order and we need the court to tell us what to do. I think the Commonwealth isn't really sure what to do. And they've said, we have it. But they've also said there's a federal protective order and they can't just violate the federal protective order. I don't think anyone really knows what to do. It's an incredibly unique situation because the feds didn't just turn it over in a TUI request like they did in the Karen Reed case. In the Karen Reed case, they requested, and eventually the feds were like, here. But in this case, it seems like those requests were met with, yeah, but no, we're not giving that to you. And the attorneys, including the Commonwealth, made a motion to intervene, and we haven't heard if the feds have allowed it. We heard that the feds said in a letter that the court also has that they thought it was inappropriate for the Commonwealth or the defense to intervene in whatever the federal matter is. So the feds are also fighting it. So it's really a difficult thing to parse who is doing what with all of this because it's tough to see. Chronic Shock said, if not fuckery, why fuckery shaped? Right. So we're going to roll the intro. We're going to go to court take 2. And it's good to see y'all. Y'all look good. Y'all look good. So are we ready? Are we ready to roll the intro? Also, law nerds, can we take just a brief second for the maiden voyage of our streaming software? Because my internet was fine, but what you guys were seeing was not fine. So, fingers crossed. We're going to see how it goes. Some of you will notice some differences. We're going to give it a whole go. Just wait till we pull up court, yeah? Let's roll the intro. Let's roll it. Let's just go to court. Hey there, I'm lawyer and legal analyst Emily D. Baker, and this is your go-to destination for live court coverage. I break down the law, the strategy, and the evidence in real time so you know what's happening. No law degree required. So join the law nerds in the chat. They're here for the facts, not and let's get to court. Are you ready? Are you ready to go to court? I know. I'm going to have to start adjusting my lights because everything's new and different. All right. Let's go to court, shall we? I know it's our job to break things. I don't want things to break today, though. We're just going to go to court. My brain is broken over what's going on in court. To be perfectly honest, I was trying to explain this conundrum and try to parse out how I would handle this situation. Because for the Commonwealth, trying to put myself in their shoes, they have an attorney that's aware of what the discovery is and has to disclose that there's discovery, but doesn't have control of the discovery because of the protective order. But the court might find that they have discovery and put the Commonwealth in the position where they either have to violate a federal court order or violate the state order or violate their Rule 14 obligations and risk their case getting dismissed or their cases getting dismissed, because there are 5 homicide cases that this involves, including the Brian Walshe case and the Myles King case. There are 5 cases here. So the Commonwealth has to say, we know this exists, but we can't give it to you. And then if the court says, but you have to give it to them, then what do? So it is a conundrum for sure. I mean, I guess we wouldn't be in this conundrum if we didn't have Proctor fuckery, though. We just wouldn't be here. But we can't go back to a time before the fuckery, it seems. So now that we're here, I understand why the defense attorneys are like, you have to give us everything. And I understand why the Commonwealth is like, we'd really love to help you. There's a federal order. Oh boy. I think they should just make Lolly turn it over and then make Lolly deal with the feds. That's my solution. Like, pick somebody to throw under the bus other than former Trooper Proctor. So we're going to court via Zoom, and away we go, law nerds. Hopefully we have fantastic sound. If I need to modify the sound, I will. It took a minute for court sound to come on, but there we go. We've got sound. Look at us.
Could I have the 2 gentlemen that are in custody brought in, please?
How's that sound? I think it sounds pretty good. Oh, I don't see let me move real quick. Let me move the closed captions. I need there to be sound so I can grab them.
Can you hear us okay?
Yes, I can.
Thank you.
There we go. Let's bring those up there. And then let me make sure that my screen is doing the right things. Are we chat? I love seeing how excited you guys are.
Is Mr. Walshe there on the video? I just don't see him. I don't need to see him, but is he there?
I don't see him.
Yeah, no, neither do I.
Yes,
the
sir.
sheriff's office is there.
Yeah,
just don't. Here we go. Oh, maybe not.
we can go get him 1 second.
The screen size is just, I don't know why the screen is fighting with me, but there we go. We're going to just leave it like that.
Identification. Let's start with the Commonwealth.
Good afternoon, Your Honor. Lisa Beatty for the Commonwealth. I'm at the table right now. There are various other assistant district attorneys who represent the trial teams on the various cases who are also present in the courtroom.
Okay, thank you.
Good afternoon, Your Honor. We're speaking on behalf of Mr. King as well as Mr. Johnson.
I can hear everybody.
I am standing in for Attorney Cataldo with respect to the co-defendant of Mr. Johnson's case.
Okay.
Good afternoon, Your Honor. Nicole Scapici on behalf of Mr. King and Mr. Johnson.
Thank you.
I know.
I have Mr. King in the back, okay?
Attorney Joseph Krosky Jr. on behalf of Giovanni De Los Santos.
Okay, and he's here. Okay, very good. And Mr. Johnson is here.
If we had a feed in court, I would pull it up, but we don't.
On the Zoom is Mr. Tipton. Mr. Tipton, could you identify yourself for the record?
Yes, Larry Tipton for Mr. Walshe. Attorney Porges will not attend today.
And Mr. Walshe is here. Mr. Walshe, can you hear us? You can just wave or whatever.
I can hear you. Thank you.
Thank you.
Just
All right,
whatever.
Mr. Tipton, we still have to fix your microphone. Still tough to hear you, sir.
He sounds great to me, Your Honor. Fix your speakers.
All right.
I think it's the court. Honestly, I can hear Mr. Tipton just great. TK in the chat said, didn't we have this kind of hearing yesterday? Yeah, on Tuesday. It was, on Tuesday. But there's hopefully more information. So
Where do things stand, Attorney Beatty?
Your Honor, I've had the opportunity to have further conversations with the U.S. Attorney's Office, and I can report the following to the court.
This is what I wanted to hear. This is what you wanted to hear. This is what I wanted to hear. I've had further conversations with the U.S. Attorney's Office. I want to know everything about it.
Ordinarily, the U.S. Attorney's Office would have 2 weeks to reply to the motion that the Commonwealth filed in federal court. We've had some productive conversations, and we're hopeful that we've reached an agreement that will narrow the issues for some period of time. They will be filing a response to our motion in court, seeking modification of the federal protective order, which will do a number of different things. The first thing, it will,
oh my God,
they will
it's
be
happening.
seeking a modification that will permit the release of the previous court orders so that this court can review those orders.
Okay.
The second thing that the motion for modification will seek is permission for the Norfolk District Attorney's Office to review the remaining confidential materials that were provided to the Reed and the Reed prosecution and defense team. So I want to be clear at this point, for the purposes of the record, that at this point in time, all of the Proctor chats or communications have been produced to the Norfolk District Attorney's Office outside of the protective order, and the Norfolk District Attorney's Office has provided those to all of the defendants who are part of this motion.
That's the Zoom.
We'll continue to provide those to other defendants. However, that left the remainder of the confidential materials, which we had not been allowed to review. So the motion will see.
Which means there are more confidential materials than just text messages. So the feds are going to modify the protective order. They are going to give the court a copy of the protective order. They are going to review materials other than just the text messages, which mean there are other materials, not just the text messages.
Permission for us to be allowed to review those additional materials. I would characterize those.
That's the motion that you filed before.
We filed a motion for that, seeking that, among other things. The U.S. Attorney's Office will file their own motion.
And they'll file a motion in accord with yours?
No, because there are what I would characterize as 2 groups of remaining materials. There are
I want to hear all about the 2 groups of remaining materials. What are the remaining materials?
Jury materials, and there are I'm
going to back that up. Grand jury and non-grand jury materials from the feds.
Before.
We filed a motion for that, seeking that, among other things. The U.S. Attorney's Office will file their own motion.
And they'll file a motion in accord with yours?
No, because there are what I would characterize as 2 groups of remaining
Interesting.
materials.
I backed this up because I wanted to hear it again.
There are grand jury materials, and there are non-grand jury materials. Their motion will allow us to review both sets of materials. We will be permitted to produce Rule 14 materials from the set of records that I would characterize as non-grand jury materials.
Okay.
We will not need to seek further court order or permission from the U.S. Attorney's Office if we review the non-grand jury materials and find Rule 14 material that is relevant to the other matters. We're calling them the other matters, these cases here that we're discussing. We do not have an agreement with regard to the grand jury matters. So if we review the grand jury matters and we find what we determine to be Rule 14 material, at that point in time, we would have to seek either a TUI or go back to federal court and file an additional motion before Judge Casper.
But they're getting it.
The third thing, this is my understanding that the third.
They're not going to go seek a Chewy, closed captioning. They're going to seek a TUI request. But it sounds like they are making steps towards getting this discovery to the defense and being able to review it. You know my personal opinion. I would love to see a neutral third party, a discovery referee, a discovery commissioner subbed in to take a look at this. But at least someone's getting to review it. So some things are getting turned over, and then they are going to be able to review and continue to turn over which is helpful. This is the beginning of a process when on Tuesday, it looked like the feds were going to be like, good luck. Now it looks like at least there's movement, and movement is helpful. For all of you asking about Rule 14, and a lot of you are, Rule 14 are the discovery obligations imposed by statute and by rule on the Commonwealth. So it's what they're required, the shit they're required to turn over. I'm so interested.
Third thing that the U.S. Attorney's Office motion or response, however you want to look at it, will seek is a status on this matter before Judge Casper in 45 days. So if Judge Casper agrees with
so this is
that,
gonna
we
be
will
slow,
not have a return or destroy deadline that is pushing the matters at this point in time.
That's better. That's better.
And does the U.S. Attorney's Office also agree to the tolling during the period between now and whenever Judge Casper decides?
Yes, they had already
agreed to that.
They had already agreed to that.
Let me just see if I can recap.
Thank you.
As best as I understand it.
Now it's time for a breakdown. Thank you, Your Honor, for recapping for us. So the judge is just filling in my role here and is going to recap what he is understanding. So let's do the judge's recap, and then I'll pause if we need to answer some questions.
There are two types of materials that have not yet been produced to the defendants in this case.
That have not been reviewed by the Norfolk Attorney's Office and have not been produced for these cases.
All right, so let me just go slow here.
Right.
Certain documents have already been turned over to these defendants under a protective order,
Yes.
which came from the U.S. Attorney's Office.
Yes.
Okay, but leaving those aside,
Some materials have been turned over. I suspect those are the materials that Karen Reed's team got. And they modified the protective order so that the materials that Karen Reed's team got can be turned over. But wait, there's more. So some things have already been turned over. And then we're looking at what else needs to be turned over.
of the materials that are part of the confidential material from the federal court, there are two categories. One is grand jury materials and the other is non-grand jury materials.
Yes.
You haven't yet defined what you mean by grand jury materials. Presumably, if the grand jury took testimony, that would include transcripts of testimony.
Correct.
I don't know if the grand jury issued subpoenas. I don't know, and I don't know if you're
And neither do they.
considering subpoenaed material to the grand jury to be grand jury materials.
They don't know.
But let's leave that distinction aside. Whatever constitutes grand jury materials, there's some other stuff that is non-grand jury materials that was collected by the U.S. Attorney's Office in connection with this investigation related to the Reed case. And what you have is an agreement from the U.S. Attorney's Office that as to the non-grand jury materials collected by the U.S. Attorney's Office and produced as confidential material in connection with the Reed case, the non-grand jury materials, even the U.S. Attorney's Office would agree to allow you to review and to determine whether anything in that material should be produced in King or Johnson or De Los Santos or any other of the cases that involve Trooper Proctor's investigation. As
Proctor
to the grand jury
problems.
materials, they still are opposing your ability to produce any of that material and opposing your ability to review any of that material. Is that correct?
No.
No.
We are allowed to review those materials in order to determine
and
whether,
then-
in our opinion, there is Rule 14 material.
Okay.
That's a big deal.
So at this point, they're taking the position that the non-grand jury material may be reviewed by you and turned over
No, all
without
of it.
further order, although I guess it's subject to their production of the documents to you other than through the, under the protective order.
I think that I want to, we don't have this finalized yet, but my impression was that we would be able to use the documents that we already hold.
Okay. And
That's the Karen Reed
are
stuff.
they taking the position, the U.S. Attorney's Office taking the position that notwithstanding the protective order issued by Judge Casper, they can make that determination unilaterally?
No.
So they're seeking a modification of the protective order to allow them
She
to
said no.
give you the authorization
Already.
to review it separately.
Yes, so this
Okay.
is all subject to Judge Casper's approval.
All right. And then with respect to the grand jury material, however that category of universe is defined, the U.S. Attorney's Office taking the position, at least as in front of Judge Casper that you can review it, and all the other prosecutors involved in this case, the other cases, the related cases, can review it to make a determination as to whether it contains anything that needs to be produced as exculpatory evidence or impeachment evidence under Rule 14. And
know that it will be all the prosecutors in the office. I think there will be at least 2 prosecutors in the office, 2 prosecutors probably who have already signed the acknowledgement, who will be able to do the review.
Who are they?
Okay.
Who's reviewing it?
And the U.S. Attorney's Office is asking for a status conference in 45 days. Presumably, Judge Casper might decide it much sooner than that.
I think what they are hoping is that they will file the motion, Judge Casper will act upon the pleadings, and then the 45 days would be scheduled from whenever it is that she issues her order, assuming that she adopts this proposal.
Well, what's the 45 days for?
For a status to see where we are. I don't know how long this process is going to take.
Oh, boy.
You mean a status on the return of documents after this review has taken place?
Right. I don't know if we'll be able to do the review in 45 days. I'm optimistic, but anything can happen. And so I think the suggestion was this way we don't have this deadline that is just pushing everyone. And so then we can see if we've been able to complete the review, if we can continue to discuss the issues that remain, or if there needs to be further litigation or what needs to happen.
Okay, so we are making progress.
That is progress.
Incremental progress.
That's better progress. But damn, what a mess. Paige in the chat asked, are they stalling?
I have not received any new filings from you or from anybody else between the last hearing and this hearing.
That's not my impression.
So all of this is being reported to me for the first time orally here in court. Maybe it's true also for defense.
There were a number of motions that popped on the docket yesterday. We're going to see what's happening there, and then we will pause some more for questions. But this is a mess because there is a split of jurisdiction of who's in charge of what, and Proctor has made everything a fucking disaster by being a disaster. If everybody had just done their job the way they're supposed to do their job, this wouldn't be a problem. But there is federal discovery from federal investigations, who knows? And there are 3 categories of discovery that they are dealing with. First, shit that was turned over in the Reed case. There's a protective order on it. They're going to modify the protective order. That's getting turned over to the defense attorneys. The AUSA has agreed. The shit's kind of already out on the horse with that. That's the easiest one. Or the horse is out of the barn, however way you want to say it. The other 2 categories are grand jury materials and non-grand jury materials. Here is my lingering question. If there are other materials that are grand jury and non-grand jury materials, then what was under the Reed prosecution? Then doesn't that seem to indicate that there may be other grand juries? Here's why I ask. We know that in the Reed case, they turned over testimony from the grand jury, ARCA, and all the rest of it. So if there is other grand jury materials that no one has reviewed that the feds have, that's not the Reed stuff, doesn't that indicate that there's more? I don't know if it does or if it doesn't, because it could indicate that the Reed case, not everything was turned over. That's not my gut on what this problem is. It could be. It could well be that there was stuff from the Reed grand jury that was not turned over. Could be. But I very much wonder if we're dealing with another federal grand jury. Isn't that interesting? So that is, again, not confirmed. That is speculative. We will have to wait and see. But there are grand jury materials and non-grand jury materials that haven't been turned over in all of these cases that are dealing with Proctor. Shocker. What is being turned over to the defense, and it seems like has been turned over to the defense since Tuesday, is the stuff that Reed's attorneys got. What they are talking about now is grand jury and non-grand jury material that the district attorneys have not reviewed yet and do not have yet, and how that's going to get turned over. So there are really 3 buckets of information that we're talking about. The Reed case is set to the side. We're talking about the non-Reed case stuff. Oh boy, oh boy, oh boy. Let's continue on. It's a lot. That's a lot of information coming in at the beginning of this hearing.
Counsel hearing it for the first time here in court. Does defense counsel have any thoughts, concerns, issues?
Yeah, Your Honor.
I'm sure you have thoughts and concerns and issues, but you know, my gut feeling here is we're going to need another hearing on this.
Yep.
And I'm not sure that
we're going to need a bigger boat, Your Honor.
You know, or a week's time. Anything longer than a week might not be appropriate because we don't know what Judge Casper is going to do. We don't know if she's going to adopt the tolling. We don't know whether.
That's exactly what
what
Judge Casper says.
Right. Right. It seems to me unlikely that she would say no, but I don't know, and I can't assume the conclusion here. So,
is there? I guess can I ask a question, Judge?
Sure.
Is there any agreement between the Commonwealth and the U.S. Attorney's Office not to destroy the documents until Judge Casper makes a decision? And can we have a day after that decision to get in here and talk to you?
What do you think?
Well, I've always said that we would not return or destroy before Judge Casper made a decision, and that the U.S. Attorney's Office has agreed to that. I do want to say that I'm out of
Nothing
state
should be
next
destroyed.
week. So
It's the prosecutor.
I would be asking to go to the following week. If something comes up, I can get on Zoom if necessary. So the only concern I have, and I'm never going to interfere with anyone's vacation. The only concern I have is if Judge Casper makes a decision tomorrow or Monday that says this order isn't getting extended for whatever reason, we're out of Judge. That's my concern. If this order expires, the order that we have right now, I know there's an agreement between the Commonwealth and the U.S. Attorney's Office, but it's not their order, it's the judge's order. So if the judge says no on Friday or Monday, then what happens?
It's a good question.
What do you think?
I will notify the court and I will get on Zoom if that happens.
Okay.
Judge, just on behalf of Mr. De Los Santos, again, in theory, this does sound like progress. I do share the concern if a decision comes out from the federal court from Judge Casper. I'm comfortable enough with a 2-week date with the caveat that if circumstances on the ground change and the landscape in federal court changes, that we could have this case advanced.
Counsel, what job did you have before lawyer? I got questions. Your Honor, if the circumstances on the ground change, then we would need to reconvene at 1200 to make sure that we have an operational plan to get discovery. Counsel, I've got questions.
To address the court.
That's where I was coming down, okay, is put this on for a next hearing, August 27, 28, 29, something like that, convenient to the parties, dog days of August, with the additional order that upon a decision by Judge Casper, all parties, all defense counsel, and the court will be notified within 24 hours so that we can accelerate proceedings on this case, if need be, before the 27, 28, 29.
I'm not available on the 27th because I have an all-day motion to do trial here in the Suffolk. Do what I have on the 28th to make myself available if that works for the court and the parties. The 28th or the 29th is better.
I'm here on the 28th.
Okay. The 28th at what time?
At 2.
Yeah, let's do 2 o'clock.
Sure.
Oh my goodness.
And may Mr. Johnson be here again?
Yes.
We're just picking dates.
Same with Mr. Delasanto.
Okay. Mr. Tipton, how do you look on the 28th of August?
I'm fine, Judge. I'll appear. If I can, I'll appear by
How much of lawyering is just picking another date? Uh-huh.
Zoom. If I can be present, I'll be present, but I'm there.
Okay. Zoom will be an option for you.
Thank you.
Anything else we should take up?
Judge, I don't want to believe.
Looks like we're making some progress, and I feel confident now that the information isn't going to be destroyed by Monday. And if it is, we'll have an opportunity to speak to you before that happens.
Okay. Mr. Tipton?
Yes.
The only thing I want to say, and I'm not going to belabor it, we'll address it on the next one, but we have, in my case, we have a trial date coming up in October. If we're talking about 45-day status date, then we're talking about the grand jury, then we're talking about TUI. I'm just putting a bug in everybody's ear.
Yeah, that's
that
getting
we do have an
long.
October trial date, and everything needs to be done expeditiously in the Walsh case at a minimum. I'll leave it at
The
that.
Commonwealth is mindful of the Walsh trial date and has expressed to the U.S. Attorney's Office that we are anxious to bring that case to trial and do not want there to be any delay, and we will be acting accordingly.
So the only other concern I have is
October?
the two attorneys that are going to be authorized. I would assume that they would have conversations with the attorneys that are assigned to the case so that they know.
Yeah, Tipton has a
I'm
right
not
to be
gonna
frustrated. Tipton's clearly done this long enough to see the writing on the wall and just be like, hey, our trial date is going to be here so fast. And if this doesn't get turned over, we're going to be getting this stuff on the eve of trial. And it sounds like Tipton doesn't want to push back the trial date because, of course, but you've got to have time to review everything. And until everything comes in, you can't even do your motions in limine, the motion to dismiss or anything else because you don't even have all of it. So it's just when. So I get it for Tipton being like, yo, we got to go, fam, let's move.
Manage the district attorney's office's obligation to produce all exculpatory evidence. They will have to bring somebody up to speed so that if they are limited in who can review the capital C, capital M confidential materials as defined in the various orders, that those people are in fact up to speed.
Thank you.
Okay.
Thank you, Your Honor. Thank you, Mr. Clerk.
Thank you.
Thank you, Mr. Clerk.
Sure. 27 at 2 p.m.
I thought they said 28.
28, yeah.
28,
What the f-
sorry, 28 at 2 p.m.
Thank you.
Thank you.
Thank you.
Is that it?
Thank
Really?
you. Could I have Mr. Buckley brought in?
Are we just going to a different case? Are we just done? I'm going to hang out and see what happens. I'm curious. But how much of trial is just this? How much of court is just this? So much? We're going to hang out and see what happens real quick. They might just be moving on with their calendar, though.
Your Honor, you're all set with the Norfolk Sheriff's Office?
Yeah, you're all set. Mr. Walsh is all set. Thank you.
Thank you, sir.
Okay. I turned the volume down a little because for the first time ever, I'm saying court seems too loud.
Great, thank you. Sure.
Who would have thought those words would ever escape my mouth?
Hey, can you let Amanda know, Amanda Mullaney?
I'll let her know.
Yeah, great, thank you.
Motion under advisement.
Great, thank you. Yes, I'm sorry.
Lona asked, did you get the rest of the video Tuesday? It doesn't seem like it exists anywhere. So no, I didn't. After they cut the Zoom off, I don't have it. And there were no new filings on that case. Jelly Bean said, when is Proctor going to testify? Not till the rest of this is handled.
Good to know.
Not till the rest of it's done.
I kept you in the loop. Mr. Buckley is present. Can I just have the parties identify themselves for the record?
Good afternoon, Your Honor. Rachel Boyce with Probation.
Okay.
Good afternoon. Ethan Yankovic on standby counsel for Mr. Buckley, who's representing himself.
Okay. Mr. Buckley?
Yes, hi. Good afternoon, Brian Buckley.
Yep.
Not related at all.
So because my memory is not so good, I keep notes. And so the last time we were together,
Same.
My notes reflect found Mr. Buckley competent to proceed. He opted back a month ago to represent himself. Mr. Yankowitz was going to serve as standby counsel.
Yeah, just
the only probation violation that was
totally
alleged is
totally different
failure
case.
to complete an anger management course that Mr. Buckley had been held for about 20 days.
Are you going to give him time served? Sure. I'm going to let the Buckley case just hang out on its own. It's not one of the ones we're filing, and it's not the discovery issue we're looking for. So we're going to talk about the discovery issues in the case that we are. All of you were like, no, I'm invested. What's going on with Mr. Buckley? He just needs to finish anger management classes, and he might get time served because there were like 20 days that he was already in, and it is just normal court proceedings. That's not, look, if we just sat and watched regular run-of-the-mill court all day, I would just be like, oh, the PTSD from being at work. Because running calendar is just next case, next case, next case, next case. And y'all are being like, what's this case about? I don't freaking know. You were like, we want real, we want court. We're now invested. What's happening? Fine. We'll finish out with the Buckley case and then we're moving on. Fine. Chat has spoken. Because now they're dealing with probation. All right. They're just dealing with probation. You don't necessarily need a lawyer to finish out probation, but chat has asked, chat receives.
Colloquy with Mr. Buckley, he admitted to the violation, and I accepted his waiver.
It's just a probation violation.
And his
he waived the probation
to a
hearing.
Violation, and
he agreed that he violated
for today for sentencing.
So he's going to get sentenced on the probation violation.
Okay.
Since then, there has been
Mr. Buckley, did you pick up a new case?
More has happened. On July 20th of 2025, he was in the town of Hingham, and he was arrested there and charged with assault and battery on a police officer.
Mr. Buckley, you're on probation, sir. You don't pick up new cases when you're on probation. So the DAs are like, well, on July 25th, there's a new case.
3 counts of that: resisting arrest and walk or ride on a track. That will be a
resisting arrest and what?
He was walking on the tracks.
Walk, ride on a train track.
Oh, I see. Okay.
And then he
that sounds like a infraction.
So essentially, this would be an initial surrender for that.
Are you filing a new case, or are you going to do another probation violation?
Well, first things first. First thing is sentencing with respect to the violation as to which we had a hearing back a month ago.
Right.
Do you think I should put that sentencing off until we have a hearing on the new violation?
Is it a new violation or is it a new case?
Honor, my recommendation wouldn't change.
Okay.
Mr. Buckley, you might find yourself going back into custody.
You agree we should go forward with the sentencing on the violation that we had, I found you in violation of on September 15?
Yes.
Okay. So why don't I hear from the parties with respect to sentencing? I'm sorry, Mr. Yankowitz.
So Mr. Buckley's going to have a chance to speak on his own behalf with regarding to the sentencing on the probation violation, but has picked up a new case or a new violation, depending on if they charge it as a new case, but depending on what his underlying case is, which we do not know, depending on what the underlying case is, they might charge it as a probation violation, or they might charge it as a new case because there were counts of resisting an assault on a police officer, and we don't know if that was charged as a felony or a misdemeanor. We also don't know if his probation terms include things like not using alcohol or narcotic substances without a prescription. And if that is the case, the fighting with the police and the walking on the train tracks sounds a little bit like substances might be involved. So there might also be a violation for that, depending on what the underlying case is. So we'll see. Amy asked, what is worse, a probation violation or a new charge? It depends on a whole bunch of factors. So it really, 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 really depends. Also, a lot of you are saying Hingham is in a different county, so they might be the ones deciding it. However, some counties will say you guys handle it. And it depends on the seriousness of the underlying case. All right, let's continue. And then we're going to summarize and answer questions on the other stuff that we've been covering.
I know I'm only standby counsel, but in my conversations with Ms. Boyce and Mr. Buckley, I think Mr. Buckley would like to, if the court would let him waive the time necessary for a final surrender hearing, and wants to stipulate to the new violation as well today.
That's correct. I'm here to stipulate to the new violation as well.
Okay.
Mr. Buckley's like, don't charge me with a new case. I'll just agree that that was a probation violation. That would be better for me. Mr. Buckley, it sounds like you don't necessarily, it sounds like you kind of know what's going on, sir. This might not be the first rodeo.
I don't have a violation package.
Yes, I just placed it on your desk, Your Honor.
Oh, okay.
Yeah.
Sorry.
Everything's in there that you would need.
Oh, all right. So they're going to treat it as a new violation.
Big package?
Yes.
The top says...
Yes.
Your Honor, you're with the law nerds now. I know that we're all new to each other, but what you can't do is start saying things like this big package. Sir. We can't even see all of your face because Jim's head is right there, but sir.
Notice of alleged probation violation.
The first packet is the older case. The next packet is the new case.
All right. Have you provided the notice of the new violation dated August 1, 2025 to Mr. Buckley?
Yes.
Okay. So, Mr. Buckley, you've seen this. It's the notice of violation, which asserts that you engaged in the following criminal conduct in a new charge, 2558 CR 545, which is in Hingham District Court, July 20, 2025, ABPO ×3, resisting arrest and walking or riding on a track.
That's correct.
You saw this. Okay.
Yeah.
Okay. Let me, as I did with the last violation hearing a month ago, I'll hear you with respect to this. I need to ask you some questions with respect to this one.
Yes.
So we need to have you sworn in.
So are we doing another probation violation hearing? We need to swoop. Because now we're doing a full fucking probation violation hearing. Sure. Let's do it.
Okay.
You could. Special Kid, you solemnly swear the evidence you give the court in the case now and hearing to the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
All right. Would you state your name for the record?
Brian Buckley.
All right. Mr. Buckley, I heard last time a little bit about your educational background. Can you tell me whether you have taken any medication today?
No, sir.
Have you had anything to eat or drink, drugs or alcohol or anything else that would interfere with your ability to understand what's going on here today?
No, sir.
All right. Do you feel like your mind is clear?
Yes.
All right. In connection with the new
these are
probation violation.
Those are foundational questions before he testifies, because he's now testifying during his probation violation, and he has standby counsel, but he is representing himself on the probation violation.
And Mr. Yankowitz is here and will be appointed to represent you if you wish him to represent you, or you can represent yourself as you did in the previous violation and have him serve as your standby counsel. Do you understand those things?
Yes, I understand.
And what would you like to do? Would you like him to represent you in this new matter?
No, I'd like to represent myself as well and still have Mr. Yankowitz as a standby counsel, if that's
All right.
fine with you, Judge.
Okay. Has anyone forced you or threatened you in any way to get you to waive your right to counsel and just have counsel be standby counsel?
No, sir.
Okay. Has anyone threatened you or forced you in any way to give up your right to a hearing with respect to this new violation?
No.
Okay. You
He's
understand
like, I'm ready to
that
just
you're
go.
charged with new criminal conduct in connection with this new violation?
Yes, I understand.
And you understand that you have a right to have a hearing on that new violation. And during that
And
hearing,
that's happening
it would be
right
the obligation
now.
of the probation office to come forward with evidence to demonstrate to the court that you in fact committed this new violation. Do you understand that?
Yes, I understand. I'm here to stipulate to the violation.
All right.
He's just like, Your Honor, I did that shit. Can we just handle it? I'm here today. Can we just take care of it? We violated probation again. Can we just deal with it now? Can we just deal with it now? So yes, now we're invested in a full probation violation hearing. And you know what? What a great way to test out day one with a full public live stream with the new streaming setup. And a lot of you have asked, Emily, did you get a new camera? No. New microphone? No. New setup? No. Just new software. So let's continue on and see if we find out the fate of Mr. Buckley.
And
why not?
Has anyone promised you anything
Full
in exchange
adventure
for your decision to give up your right to a hearing and to stipulate to the violation?
No, Judge.
All right. I will accept your waiver of your right to a hearing. I will accept your stipulation to this new violation, and I'll hear from the parties with respect to disposition and what I should do in connection with these two violations. The earlier violation with regard to failing to complete the anger management program and the new charge.
Thank you.
Thank you, Your Honor. Probation is recommending today that Mr. Buckley be released on a GPS bracelet with the condition that he remain out of the town of Hull, because that is where the victim from the underlying case lives. And in the first violation, he did make some unsettling remarks about wanting to get his children and things such as that.
Can you speak into the microphone? It seems like Mr. Buckley's having difficulty hearing you.
He did make some remarks.
It seems like we're having difficulty hearing in this case. This courtroom apparently has the worst fucking acoustics we've ever heard of.
About wanting to get his children. I understand that's very difficult for him. However, there is an active restraining order, which his children are named in. The victim in the underlying case has also told me that some of her neighbors have seen him in the vicinity of her home.
So
since
why
being
is
released, which makes her very nervous as well.
So if it's a domestic, why a bracelet? Because that's not going to help. This is not my jurisdiction. Not my jurisdiction.
I reached
not my
out
jurisdiction.
to Bay State
not my
Community
jurisdiction.
Services to see if he could be reinstated on the intimate partner program. They said yes, he can.
That's why the
he would
anger
have to
management
pay
classes.
his past owed balance of $110, and then schedule and attend a re-enrollment intake, which would be about $50. And then after he does that, he can continue on with where he started or where he finished. He wouldn't have to start over with that. Also, I have talked to their mental health unit, and they have room in their agency for another patient.
I'm sorry, the what unit?
Well, that's good.
In their agency. They have another.
What's the agency?
Mental health.
Okay.
At Bay State.
Well, that's good.
And he could go back to that.
He can go back to that for both the intimate partner and for mental health treatment. The way it works with them is it's an all walk-in basis. They have walk-in hours on Monday, Wednesday, and Friday from 9 to 12, and then Tuesdays from 4 to 6. He would have to walk in to their facility and tell them that he wants to get mental health treatment, and they would start with an assessment process with him and see exactly where he needs to be as far as treatment is concerned.
Okay. Did you hear what was just described by the probation department?
Yes, I did, Your Honor.
Okay, and so they are suggesting that I reprobate you, I assume, to the original end date.
Yes, Your Honor.
To the original end date, so not extend probation, release you on GPS, and the GPS would be designed to enforce the condition that you remain out of Hull, that you don't go to Hull. You never step foot in the Hull, okay? And if you go into Hull, the GPS is going to register it, and there's going to be a warrant out for your arrest. So it pretty much happens automatically.
Yeah, the thing is,
have no direct or indirect.
Those things don't register immediately. So I don't know if that helps the victim feel any better, because yeah, it'll register, but it's not going to stop someone from going where they're going. But probation knows this person better than I do. We're just a fly on the wall. So we're just a fly on the wall. Probation's more familiar with this than we are.
Contact.
I don't know where Hull is. No idea where Hull is.
The victim in this case, that you get mental health evaluation and mental health treatment as deemed necessary, and you can do that through the Bay State program. That you enter or resume and complete the batterers program. Again, you can do that through the Bay State program. Is there a restitution order?
There was restitution ordered.
Okay.
He has been in compliance.
Okay, and so you'll have the restitution obligation that will continue. Any other conditions that I missed?
The only other condition was that he stay away, have no contact with anyone listed on a current 209A order.
That's a domestic violence stay away.
Referral.
Well, it'll be comply with any restraining orders. Okay, that will be the condition, is comply with any restraining orders.
Obviously.
If you violate the restraining order, you go and contact somebody, or you have somebody else contact them for you, anything like that. That'll be a violation of your probation. Do you understand?
I understand, Judge.
Okay. All right.
And one other, I'm sorry,
Yes.
Judge.
Okay.
I did a referral for BHJI a couple weeks ago, which is the justice center that helps people who have been incarcerated get back on track. They have met with him. There was a letter that Lewis Howe wrote today regarding his work with
I think someone actually just handed this up to me.
Bay State Community Care?
Yes.
I hope they will help
like
him get to his appointments.
any
I mean,
services that they
we would love for him to follow through. Will they help him get to his appointments to get to his services? Because that would be helpful.
can provide for him.
I have no idea what that means.
Basically,
no. I want to write a condition. If I'm going to write a condition of probation, I want to be very clear about what it is.
That's fair.
So that you know what you have to do, and I know if you violate the condition. Okay. And Riverside Community Care.
We kind of want you to do a thing. That's very fair. It doesn't help if we kind of want you to do a thing that really doesn't let anybody know what the thing is. It's like, well, okay, but do I have to? Like, is this a suggestion? Is this an obligation? I appreciate the court clarifying it during the probation violation that is happening at the end of the case that we were watching. So why not?
Provides lots of potential services that they could provide for you. But for example, mental health was going to be provided through some other agency, right?
Correct.
Right? Intimate partner violence program is going to be provided through some other agency. So what specifically do you want Mr. Buckley to do through Riverside?
They also have programs where they help with job placement.
Good.
They provide rides. Last time they
That's
brought
helpful.
him home when he was released from jail. It's just if there are services that they can.
So I'm not going to impose as a condition.
Okay.
That's helpful.
The obligation on Mr. Buckley to get resources that some organization may or may not be able to provide for him. Okay. I think Riverside may well have resources that would be helpful to you. Might be to your benefit to take advantage of that, but I'm not going to impose it as a condition.
If they can give him rides to finish the program that's required as part of probation and help him get to the program he needs to get to as part of probation, then it will actually help him complete probation if there is some assistance getting it done.
Okay, thank you, Judge.
Okay. Okay, anything else, Ms.
No,
Boyce?
Your Honor.
Okay. Anything else, Mr. Buckley?
Yes, I had a small statement. It'll go quick.
He is being sentenced on the first probation violation. We haven't gotten to the second probation violation. He's getting sentenced on the first probation violation for whatever the underlying case is that we're just hanging out in because our case is finished. So I'm interested to hear what Mr. Buckley's statement is about being put back on probation.
I've been seeking further health mental treatment with an outside provider. With the initial violation for having to go to Bridgewater, I believe I am a victim of the Abington law and systemic racism, but I'm not a risk to the public or police and will have a psychiatrist by Monday. Part of my aftercare plan is my children. My 5-year-old daughter turns 6 next month. She is very precious to me. I want to move forward with DCF for supervised visits. I've had no accurate update by DCF since they closed the case over a year ago. I want to be involved in all my children's lives. I have 3. My 7-year-old son is autistic, and I'm working with a will and state attorney to plan for my children's future so we can grow strategically. I've been working on my children's family home, which has been in our family since 1905. It was sadly destroyed by their mother, who caused hundreds of thousands of dollars worth of damages. When released, I would like to focus on my mental health treatment first. I'm willing to enroll in an outpatient mental health treatment setting and/or facility to build a strong mental health support team for myself.
That's a good plan.
I would like to seek further mental health treatment with an IOP plan. An IOP plan is intensive outpatient therapy.
Yep.
When I was released by yourself, I encountered even more racism on the ride home, on the train ride home. Because of my skin color, I was asked to get off the train at the next stop. This was after I explained to the conductor I was just released. I politely informed the conductor that he would have to call the police if he needed me to be removed from the train. My father has the same birthday as Rosa Parks. I've worked in Brockton on the Frederick Douglass Tree Memorial. Clones of this tree I preserved at the White House. I was not rude to the conductor. I had no phone and was too tired to get the information to report him to an MBTA official.
You told them to call the cops.
Experience for me, and I'm seeking more mental.
Sir, you told him, if you want me off this train, you need to call the cops. I have questions.
Health treatment because of the incident. I would like to reintegrate myself back into society slowly through an IOP program. My family is small, but they are very supportive. Most of my neighbors see the improvements I've been doing on the house. I've been working hard to see my children again. I've completed a nurturing fathers course, a parenting class, and a domestic relations class. I need time just to rebuild my landscaping business to support myself and my family.
Sir, it sounds like you didn't finish the classes.
I'm a good person with good morals and ethics. I just want help by the right people who want to see me succeed. Yes, I do have PTSD from police brutality over the course of 22 years. But I do not want to fight. I do not want to argue. I just want to see my children after I get more mental health treatment. My mother was a school teacher who passed away in 2009. She taught foreign language, French and Spanish for over 41 years. On the weekends, I would help her grade and correct papers. I started correcting papers when I was 12. She passed away August 12th, 2009. I made peace with her passing, but it was hard. I was 22.
I mean, losing a parent is hard.
I qualify as an ADA patient due to all the trauma I've endured over the years. I'm asking to be re-enrolled in the Batterers program.
They already said you could be.
In my IOP plan, I would like to address my trauma, work on emotional regulation, and start to discuss my family therapy plan since I have been absent for so long from my children's lives.
I mean, they had you
with
in
an
an
IOP plan in place.
anger
I would stay in
management
touch
program.
with Lewis Howe. To make my IOP appointments on time and safely, Mass Health provides a PT1 transportation service to mental health appointments for free.
Good.
I can attend any in the state because of this service.
Good. That's a good service.
In my treatment plan, I will apply for supervised visits with my children during the end of my treatment with my treatment team's approval. A solid goal to see my children will help me greatly in my mental health stamina to see my children safely. I understand that I'll have to ask another judge out of another court for permission to see my children.
Yes.
I hope we are all on the same page that my mental health treatment needs to be addressed first.
It sounds like they are.
I'm not a risk to the public or the police. I'm asking for the town of Hull just to be added to the restraining order with no GPS.
Nope, that's not happening.
May I please have a 1-day travel permit issued by the court so I may go home without incident?
No, you're gonna be on a GPS.
All right, Mr. Buckley, thank you for those comments. Okay, I appreciate your commitment to maintaining your mental health, and that.
It does sound though like the new violation happened on the day he was released on the way home. So I hope that the outpatient program, with the added at least awareness that he's on GPS, will help him follow. There's a process that you have to follow. You can't just do the things. But he's going to be on GPS.
That's a priority for you. I think
it sounds like it's a priority.
Getting reestablished with your family, your kids, is a terrific goal. But obviously, that has to go through a proper channel, and
right,
you
there's
know that.
Processes.
Yeah.
You have to follow the processes.
I think being successful on probation is a big piece of that.
Oh yes, I agree.
You know? And so what I've tried to do is I've tried to give you very specific probation
guidelines,
conditions that you need to comply with, and I think they're conditions that you can meet, and that in your statement you articulate that you want to meet. I am going to impose the GPS condition, though. You understand that, and that's a hard condition to comply with because you have to keep the GPS device. I don't know if you've ever been on GPS before.
Charged.
You have to keep it charged. You have to, you know.
It's 2 hours a day to charge it. I understand. I've been on it before.
Okay. So.
Not first rodeo.
Where are you going to be tonight?
My house in Cohasset.
In where?
Cohasset.
In Cohasset. Okay. So, and how are you going to get there?
I have to take the train.
Okay. Mr. Yankowicz, can you work it out so that there's no problem with him getting there?
Get him transportation that's not the train.
So, you'll be released today on GPS on these conditions. You'll have to meet with Ms. Boyce before you leave because she's going to have to fit you for the GPS device.
Have probation get him home.
You'll be good to go. Well, we can impose the sentence.
Yes.
Yeah.
Okay. Mr. Buckley, the court having found you in violation of terms and conditions, your probation.
So the clerk's reading in the probation violation, he's being sentenced.
Term with the following conditions. The GPS will be with the exclusion zone of Hull. No contact with the victim, mental health treatment. Resume the batterers program. Comply by all restraining orders, and all of the conditions remain that were originally imposed. Good luck.
He said it was his family home since 1905, which is Massachusetts stuff.
Yeah, thanks, Mr. Yankee.
Are we?
And just for the record, as far as you know, Ethan, there's nothing else holding him?
No.
Okay.
He has the next date in Hingham, and he goes to bail on that day.
Great, thanks. Thank you.
All right. So what are they going to do with the new violation, though? What are you doing with the new case?
Could I have Mr. Rivera brought in? Yeah. Ms. Boyce is going to do it.
No. All right. Well, it sounds like Mr. Buckley is going back on probation. He's got a new case in another jurisdiction, and they're going to have to deal with that, and they're going to try to get him home. Lona, what do you mean the house has been in the family since 1905? That's what he said on the record. He said he is working on fixing up his family home that's been in his family since 1905, meaning his parents, grandparents, great-grandparents, however many generations it goes back to get you back to 1905. That's how long they've had the home that he is going home to in the evening. But yes, probation violation is sentenced. That's a previous violation. There's a new violation. The new violation might also be a new case. We will see, but not a first rodeo, as he was like, yes, I understand what I need to do on the ankle monitor. That's not my first rodeo on the ankle monitor. And away we go. So hopefully he will go into the treatment programs and successfully complete the probationary conditions without hurting anybody. That is the goal, to find the balance of helping people get their lives back together and get themselves back together without harming anyone else in the community. And that is a balance that judges have to try to balance in every single case that comes in front of them. How do you make sure that the person in front of you gets on a path that they need to be on? And then how do you make sure that when they are on that path, they don't harm anyone else? And that is sometimes a difficult balance. Sometimes that balance can't be struck. And the court is like, no, you are not going to be doing probation. We will see. But Mr. Buckley was like, I'm admitting my violation. I'm admitting the new violation. Can we just keep going with probation, mental health, and classes? Hopefully they help, because it is not an easy road. So we will see. But on other things we did today, let us swoop with our updated swoop. Let us swoop and do a summary of today, and then we'll just answer some questions. And then and then I've got to go do school stuff because it's the beginning of the school year, and it is a very busy time of life for me. So let's continue on. As a summary for the hearing that we watched today regarding the discovery in the plethora of Massachusetts cases that are dealing with the Proctor fallout, it sounds that the Commonwealth has made some headway with the feds to start getting discovery turned over, which I was actually surprised about. That shit happened between Tuesday and today. I'm just really surprised that we are in a place where we came into the hearing today. It was a pretty short hearing, but we came into the hearing today and heard the prosecution say, look, we can turn over the things that were under federal protective order. That's the first group of stuff. The things that were under federal protective order. That federal protective order is being modified. That's a lot of what was discussed on Tuesday. The things that were under protective order that are in the possession of the DA's office, the Norfolk DA's office, is the stuff from the Karen Reed case, right? So when the Commonwealth said we can turn those over, the protective order has been modified to give those to the other defense attorneys, those things will get turned over or have been turned over. That's the first bunch of stuff. The next two groupings of discovery are things that the Commonwealth represented to the court that the feds are allowing the Commonwealth to review, which are grand jury materials and non-grand jury materials. So two additional groups of discovery that the Commonwealth has not yet seen. Is that the same grand jury as Karen Reed, or is this a different grand jury regarding different investigations and different things? I do not know. We will see. It's possible that it's the same, but if it is the same, why wasn't it already part of the discovery turned over in the Reed case? So is it not the same? Perhaps it's not the same. Do we know that for a fact? No, but the question lingers. If the grand jury materials are being turned over and no one has seen them yet, and they weren't turned over in the Reed case, is it something separate? I have to wonder if it is. And then there are non-grand jury materials that the Commonwealth has not reviewed and has not reviewed to turn over. So it seems that where we're at is the materials that were turned over in the Reed case are getting turned over, that the materials from grand jury that have not been turned over and non-grand jury that have not been turned over are going to be reviewed by the Commonwealth to determine if they need to be disclosed and turned over. And then they will determine if there is an additional protective order that needs to be turned over if the federal court agrees that it can be turned over. So the federal court has agreed to a little bit. The feds said you can review it to see if there is potential discovery that needs to be turned over. And then we will see if the federal court allows that to be turned over. So it's like a two-step process for the next part. But that's actually just a lot of movement in 2 days. And I have to wonder why this couldn't have been done sooner. I don't know. Maybe the deadline made everybody move a little bit quicker, but they really did make quite a lot of motion in this case between Tuesday and today. So the court set a future hearing on discovery, process of discovery, and the rest of it for August 28th. I was looking down as I said that, but for August 28th, 2025 at 2 p.m. We will probably be in trial, so we will record it and get back to it a different day because Brian Walshe's attorney, why everyone is named Brian, I have no idea. But Brian Walshe's attorney said, this is all well and good, but like, we have a trial date in October 2025. It's almost September. Like, if we don't have discovery, we don't have a ruling on our motion to dismiss, we can't even start motions in limine. Like, tick-tock on the clock, y'all. We have a trial date. And I think that the other defense attorneys are probably in a better position because the Walshe case is moving forward to trial. So if it's getting handled in the Walshe case, the other 5 cases are going, or the other 4 cases are going to be benefited by that because the discovery in their cases will move along at the speed of the Walshe case. So it looks like when it comes to the Brian Walshe case, I imagine that case will be televised and the discovery motions will be findable. And I definitely need to find them. But it looks like we're going to be keeping an eye on the discovery in the Walshe case and the King case a little bit more because the Proctor problems aren't done and we're invested now. So here we are. The Proctor problems aren't done. And then there's stuff moving along in the Karen Read civil case. There are other cases that we want to loop back in on. But as we talked about yesterday, the Donna Adelson case is getting ready to go to trial next week. So we're going to be in trial just a little bit. And then we are going to circle back to this because by the time we're done with the Adelson case and a little bit of travel for me, it's going to be October. So the Walshe case is going to be right around the corner. And I don't think we have anything on the schedule because we were going to be covering cases in Idaho and we're not. So I think we might have a little bit of room in October if that case goes to trial in October because it'll be done before February when we are going to be in Utah. So we have lots of plans, but it feels like the fall is here and it's just going to be trial, holidays, Corey Richens. But it seems like that's kind of where we're going to be for the next few weeks. We're going to, I'm closing the notes. We're trying out a new notebook. I'll keep you guys posted. But we're going to get to Q&A. Members, we are going to record a podcast this week. I'm going to have to narrow down the amount of stuff that is on the docket, but we're going to record a podcast this week. So we'll be doing a behind the scenes recording in our new software. For those of you that popped in and are like, Emily, everything looks different. Yeah, it does. Yeah, it does. Thanks, Team Baker. It's fantastic. Let's see. Angela A asked, what did King do? The King case is an alleged homicide. It's a shooting. Also, what do they have on Adelson besides the phone call? Oh, Angela, we've got a whole episode coming up on that. So, there's a lot for Donna. There's wiretaps, there's emails, there's testimony, there's a lot going on. So don't worry. Goal said, I'm hungry for food court, please. I know. Julie Maud said new software. Who dis? I mean, 100%. Ty said a new notebook. I've been considering the Remarkable. I am working with a new notebook based on my use case. So far, I'm very excited, though I want to make sure that as I'm using it, when the newness wears off, I am as excited. The problem I was having with the Remarkable, I love writing on the Remarkable. The problem I was having with the Remarkable is how difficult it was to deal with PDFs, and my workflow is very PDF heavy. So if you do not have a PDF heavy workflow, it might be the right solution for you. If you do have PDF needs, it might be that another solution is right for you. So right now I'm using the Supernote Manta. For some people, the size is going to be too big and they might want the smaller one because there is a smaller one. But I'm using the Supernote Manta because it syncs with Google Drive so easily, and you don't have to pay for something else to sync with it, which is a feature with the Remarkable. And so there's some things I really like about it. I'm going to keep using it, and I'll keep you posted if you are not urgently in the market. But for writing, the Remarkable has a great and easy system to use. The Supernote is a delight and syncs so easily with Google Drive. So easily. So, all right. Miss Artemis Fowl said, when are we going to do the thing we didn't do on Tuesday? I don't remember what we didn't do on Tuesday. There is no additional video that I can find from Tuesday. I can't find anything from Boston 10 or anyone in court, and the Zoom ended. I have not found anything, and there's nothing filed. So we'll see. A lot of you are saying that the chats are just a tick small on the screen. I appreciate the feedback, and yes, we can change it around. We can change it around for sure. Proctor's IA file. We will talk about Proctor's IA file another day. The IA report. That, yes, I will make a note. We're going to go over the Proctor thing. We have some other read stuff that's not a hearing that we're going to go over, so we will put it all together. So once we grab it, we will put it all together. Unfortunately, today is not the day, just because I have a hard stop because I've got stuff at my kiddo's school. Goldie, yes, those of you that have the TV live chat scrolling, I always turn the TV live chat off, so I always forget where it shows up. Because I always keep, when I'm watching on TV, I always keep the chat on a device because I can't read it from screen. So it's tough, but yes, we will get there. So Bree said, do I need a Remarkable? No. Does my ADHD want one now? Absolutely, yes. Look at all the e-writing devices and see what you think. Jane, the Morrissey emails are on my docket. I just haven't gotten them yet. Julie said the color looks so much more vibrant. I know, it's a whole different world up in here. But I don't have all the Morrissey emails yet. I have not grabbed them. We will do a summary of them. I don't think we're going to go over all of them because it's like 4,000 pages of email, but we will go over highlights when we have a chance. So, all right, let's get to the rest of questions. I didn't roll our I have questions yet. So we should just do that. We should officially get into questions. The artful colorist at the end said, I just can't give up my paper notebooks and fountain pens. I get it. Everyone has a different use case. I would never tell you what the best use case is for you. For me, I really needed some different solutions because of how PDF heavy my use case is, which is unique to me. It's just a different use case. I think what matters most is how you want to use a thing and then find the thing that fits that, because there are things that are delightful to use, but if it's not how you need to use it, it doesn't matter. So that's kind of where I'm at on the e-ink writers. And if you heavily read books in EPUB format, that might be a different solution. If what you want to do is write and sketch and draw and you need color, that might be your solution. If you need an e-ink notebook where you can write and do PDFs in a more like kind of academic workflow, less creative workflow, then that might work. It's just a whole bunch of different stuff. Does anyone know where to finish watching That Judge's Courtroom? Mellow? No, I don't. There was only one more hearing before the Zoom was done. So, and that was the Zoom from today. Moo Boy Moo said, why is everyone in Massachusetts named Brian? I have no idea. It's probably a Catholic thing, honestly. It probably is. But I don't know. It's a lot of Brians. Like it's a lot of Brians. It's a lot of Brians. So I'm trying to grab this question in the chat. Ems in the chat said, do any of them actually get you to do things? If you enjoy using it, it makes it a little easier. So maybe that, because if you enjoy using it, it makes it a little easier to use. I also will just note some of our member names are not showing up with their gavels, Miguelina, if you don't mind making a note. It's also an Irish thing. I mean, the Irish Catholic thing kind of loops its hands together, doesn't it? It's fair. So, though I was going to say the Italian Catholics I know, also a lot of Brians. Miguelina, some are showing up with gavels, some are not showing up with gavels, Cat Mom. So that's a note we need to make. So the gavels I see on my end, but we're not seeing them when I pull them up. So we're just making notes on how things roll, and we're going to keep making improvements because we rolled out early because today things just were not working well. Mandy Kirk said, why do you think the FBI are refusing to help? It's not the FBI that's causing the stalemate with the federal discovery. It is the U.S. Attorney's Office. It would take speculation for me to say what's going on with the U.S. Attorney's Office. It could simply be the fact that there is more going on, and the U.S. Attorney's Office is very protective of not giving people a heads up until they are like indicted. So it might be that there is just more going on, and they want to make sure that they're protecting what they're doing before they turn things over. So there's much happening. And I would imagine that that's part of why the AUSAs are like, our shit comes first. Like, I don't care about your state prosecution. Our shit comes first. Tiffany said, our flight to Mass is delayed. Who needs a Starbucks? I mean, 100%. 100%. Valerie Holmes in the chat asked, is it only the prosecution who will get to view the information, or will the defense represent, will the defense represent too? The prosecution gets to review it first before it's turned over. So it will be the prosecution first. We will have gavels for the YouTube members here because that is all connected through YouTube chat. We can't connect it through our app. It's only connected through YouTube chat. But even though it's connected through YouTube chat, it's not showing up quite right. Patty said the FBI. I mean, it's fair. We didn't. The FBI. We needed to. Let us continue. So, let's see. I'm grabbing some of our comments. Taz said hi from Ireland, watching on my lunch. Good to see you, Taz. And let's see. Randy said, your snark makes me happy, Emily. Happy 17 months. Some days there's more, some days there's less, but we'll see. K Soaks said, please say happy birthday to Iran, who will be 7 tomorrow, but starts his birthday with a hospital appointment. I'm sorry for the hospital appointment. However, happy 7th birthday. I hope I pronounced that well. My phonemic awareness is non-existent, but have a very, very happy birthday and take care. Hopefully there is something fun in the plans for the birthday. Elena said, I just got put on a grand jury and nobody in my life understands how excited I am. Congratulations, Elena. When you are all done, I hope you share with us how the experience was for you. You cannot share what you cover, what you go over, what you do, but I would love to hear how the experience was for you and the things you enjoyed, didn't enjoy about it, and the experiences that you had. I would love that. That would be a lot of fun. So let's see. Alioup said, after watching older streams in 1.5, everything feels like it's in slow motion today. It's fair. When we are live, if you are caught up on real time, you can't 1.5 me until we are on replay crew. So that's part of it. Sophie said, in the UK, if you're in your 20s, everyone's James, Sean, or Kieran. Sean! Emily has just defaulted to Shaun of the Dead. Yes, that's fair. That's fair. And it's so funny how names kind of go in fashion and out of fashion. And you can tell there was a very significant period of time when it was like everyone was an Aiden, a Hayden, a Caden, like every single name was like, Hayden, Caden, Aiden, Braden. What the hell? Travis. Exactly, Travis, which is part of why Travis. Shaylin, I didn't plan that. I didn't plan that at all. Shaylin. So perfect. Could they be forced to dismiss the case if they do not get the evidence turned over? Yes, it can be an issue. However, as I mentioned in previous cases, when you look at the law in Massachusetts and you look at the case law in Massachusetts, the defense has to prove that something is exculpatory before dismissal is the remedy. And the question is going to be, if they don't know what it is, how can they prove that? And that becomes a difficulty. But yes, on the motions to dismiss, it's going to be a whole thing. It's going to be a whole thing. So, Emily Ippolito said, apparently Emily was the most popular girl's name for 10 years running, and yet I have only met 2 other Emilys since high school. I think it really, I know it was. I do not meet a lot of Emilys in real life either. So it's there. Goldie said YouTube has ruined me with 2 times speed, and IG and Facebook gave them 2. I use it all the time. I do too. I speed things up almost all the time. All of the Din names were popular when Kellen and Ronan were born. We were determined to be different. Ronan's a great name. So is Kellen. It's like, no, we're not doing it. I think Alessi has a remarkable. I didn't get to ask him if it was a remarkable or an iPad, but it was it was definitely a larger size that he was using to write on. Rune Munch Peterson said, today in Denmark, if someone is named Emma, they are either 20 or 80. Which is very fair. You can definitely see the generational naming, which is lovely. Natalie said, I have a cousin named Emily. It's one of my favorite names. It's so pretty. Well, thank you so much. I was going to be a different name, and then one of my mom's friends had a kid like a month before me and named their kid that. And my mom was like, well, shit. We need to pick a different name. But yes, it's funny how they are generational. And sometimes you can see when they tie back to like music or movies or what have you. Angel said, getting a better nib made Remarkable better for me. That helps too. The Remarkable nibs that come with that Remarkable. I like the Remarkable pen a lot, but the nibs wear out pretty fast. Jojo asked if I saw the Morrissey emails. I haven't seen all of them. I have seen reports about them. Part of it has been because it's been a bananas week getting Travis like reoriented to like life not on tour. So it's been a busy family week, and we're going to have those weeks, especially when it's like back to school time, which is way early for some of you, late for some of you, but it's back to school time. Mello said, can you explain why both sides don't get everything? If something is simply irrelevant, why not share it? In the sense that no harm, no foul. There are rules of discovery, and things that are not related to the case wouldn't get turned over. So if something is related to like the King case, but not the Walshe case, the Walshe attorneys don't necessarily get it because it doesn't even apply to their case. I don't know what the discovery is, so it's kind of hard to parse what may be there. But if it's completely not relevant to a case, it would not get turned over. And the feds don't want everything going everywhere, especially stuff that has been under protective order. But I also understand the hesitancy of why are we letting the Norfolk DA's office decide? I get it. Maybe we want someone else to take a look. I understand that. I kind of want somebody else to take a look into it too. So we'll see. For those of you asking, who is Michael Morrissey? Morrissey, not the singer, not Carrie Morrissey, the special prosecutor in New Mexico, the elected DA for now in Norfolk County. I imagine that's going to go differently. I imagine. Narda Navarro said, will there be a Brian Koberger video on the new information released? I will do a summary of it. I don't know if we're going to do a live or if I will do it in podcast form. I haven't had a chance to go through all of it yet. So yes, I will do a follow-up, but it's not something I'm going to follow super closely. So it's something I will follow up in chunks of information because the Adelson trial is coming up and we've got some stuff to do with the Adelson case first. So yes, but not super quickly because, again, I want to go through it all to see if there's new information, not just salacious information, but new information. And it'll be interesting to see where some of the complaints go. I have seen rumblings that he has been complaining in custody that he doesn't love the accommodations. Okay. I suspect, and I said this multiple times when we were going through the Koberger plea and sentencing, I said multiple times, I suspect at some point he will be moved out of Idaho if they get to a point where Idaho feels that they cannot keep him safe. But he seems to not maybe love prison. So, you know, seems like people are saying mean things to him. So, yeah, sure. I don't know. I'm just wondering what he thought that was just what he thought that was going to be like. Because local custody and prison are not the same thing. Like local jail where you are waiting for trial and prison are not the same. It depends on what state you're in as to how different the two of them are. Because in Los Angeles, some of the local custodies are very large and are more of a prison-like environment. Sometimes they are not. It really just depends on the custody situation. But it seems that he's not happy in prison and people are keeping him awake at night and saying words to him and yelling things. Okay. I mean, it's just you can't sleep? Sure. You know who else probably can't sleep? All of the people impacted by the shit that you pled guilty to. So I'm so troubled that you can't sleep. I'm so deeply troubled that you can't sleep. It's so weird that the other custodial inmates would like you to know that they do not think that you are a great human. But from everything I've gathered, he has not been physically harmed and custodial situation is keeping him safe and his feelings are hurt. So, okay. Whatever. Everybody's like, where's the tiniest violin? He doesn't even get the tiniest violin. No tiny violin for you. Too bad. It's so hard for you. Anyway, if we see any official reports that come out about the things he's complaining about, I will read them so we can all roll our eyes together and go, what a bummer for you. But again, their job is to keep him safe. So they have kept him safe. It doesn't even seem like he's been gassed or anything. So as far as things that can happen to someone in custody, it seems like it's been annoying to him, but that they have kept him safe. Okay. They'll continue to keep him safe. That's their job. So you're safe. Oh, sorry. Gassing. People aren't throwing bodily fluids and things at him. So, which is something that happens a lot, but people aren't, he has not been, how do we describe this in a YouTube-y way? Look, sometimes when even people are kept separate from other inmates, there are, Doctor Who said, Emily, that's some shit. Yes. But also like, no, because it seems like that's not happening. So sometimes when people are kept separate There is more like chain link, which is things can go through chain link. Even though it can keep somebody from like getting directly at you, things can go through them. So, it doesn't even seem like he's been like any of the things. So, none of the bodily fluids or fecal matter or anything like that. So, mean words. But it does happen. So, I also think if people are like, and then somebody threw pee on him, the chat would just be like, I mean, he's alive, yeah? Nobody stabbed him? Then again, given the things he's admitted to, I even think at that point, some would be like, well, it's the job of those in custody to keep you safe. So it sounds like they're doing their best. Okay. It must be hard to be you. But we will get into his complaints if I see the written complaints. We'll get into some of the new information released if there's new information. We tangented it a bit, but we will get into the rest of it. If he thought that prison was going to be like local custody, well, that's an unfortunate assumption, isn't it? Yeah, it is. Yeah, it is. Jake B asked, are George and Fred happy to have their person home? George is still a little salty, but he's coming around. But George is still a little salty. Julie said, other inmates are saying he doesn't even go here. Yet there are some. Look, societies have rules. Different groups have rules. The rules in custody are nonetheless rules. They are different rules, maybe than what you are used to in your community, but it is still rule-based and very much power structure-based within custody. And Brian Kohberger doesn't fall on the top of any of those heaps. Plus, there are crimes that those in custody do not forgive at all. So, he falls in to the category of crimes that are not well regarded. And it seems that maybe in his studies, he had not gotten far enough along to really study prison culture vis-a-vis serial killers. So, it seems that maybe he's a bit surprised by the different culture within custody where he doesn't maybe understand what that culture is going to be like. And some will navigate that better than others. But here's the thing. Kohberger, it's not like this is unknown information. So it's interesting. Have you guys watched Todd and Julie Chrisley talk about their experiences in federal prison? They've been talking about it on their podcast. They're filming a show. If you want to hear about someone who has come from, mansion and television show to federal custody, which is definitely different than like Idaho Supermax, listen to their experiences. And I'm sure there are people on YouTube who talk about not just prison culture, but helping people prepare for it. This is more common in the federal system. Anyone watch Dance Moms? Didn't she go to a prison consultant? There are prison consultants. Yes, there are. This is a thing that exists. But in federal crimes, especially when you're dealing with non-violent federal crimes, you generally have a chunk of time before you turn yourself in. And so people get prison consultants to figure out what the fuck they're supposed to do. Teresa Giudice hasn't talked a ton about prison and her experiences in prison, but others have. And I'm sure there are YouTube channels that talk about it too. So it's a whole different thing. And then federal is different than state, and Supermax is different than everything else. My understanding comes from where I worked and those that I had conversations with, and the work that I did and the things that I saw. So it's going to take him some time to adjust. Ippy Fluffy said Dance Mom's Abby. Yes, Abby Lee Miller went to a prison consultant before she went into federal custody. So what type of prison is Brian Koberger in now? He is in the Supermax prison, so he's being kept like where they keep death row inmates. So kind of the same. Yeah. So it'll just be interesting. Stephanie B said, do you ever wish you did defense work? No, Stephanie. No, I knew. I've talked about this in the past. A, my face has subtitles. B, I am not always patient. C, it does make me kind of crazy when people ask or need advice and then don't listen. It's why I also didn't do family law, because it's like, hey, don't do that. And then they go do it. And then you're like, well, you did that. I have enough patience to parent. I don't have enough patience to parent an entire caseload. And the nice thing about the DA's office, and I think I would find this very frustrating if I was on the other side of criminal law work, is that if there was a case that I was like, this case shouldn't be filed, I got to not file it. When you are on the defense side, you have to convince someone that they shouldn't or should do a thing. So there is a level of control that matches my personality very well in the work that I did. In a role as a defense attorney, one, I don't think I have the requisite patience. And two, you are stuck with whatever the relative DA you're working with does. And I think that level of frustration would completely burn me out. Just completely blow my mind. Because you see Alan Jackson in court wanting to blow a gasket over not getting discovery and what have you. And that is a difficult thing, especially coming from being at the DA's office, where Jackson was like, when I did this job, I know what it entails. Why can you not do it? Do your job. What are you doing? And so there's a level of frustration I don't know if I'm built to tolerate, but we'll see. Insider info, Cat Mom said Julie's unit team loved her. Todd's absolutely did not. It seemed that Todd got along with the other inmates, but not the staff. So, LH said, just imagine EDB being a defense attorney in any of the Proctor cases. I would get held in contempt is the thing, because I would lose my shit, and that's not helpful. If discovery showed up in the middle of trial that someone could have gotten to me before, because it wasn't like a thing that happened that morning, I would lose my mind. And the court would be like, okay, counsel. And I'd be like, you don't understand. No. I know my personality. So it is, look, we all get to kind of pick what we do the best that we can. And I tried to work with my personality the best that I could. What I didn't accommodate for enough was my ADHD. I should have accommodated that better in my career. I was just like, we can just push through it. No, we can just push through it works for short periods of time, not as a life plan. Law nerds, thank you for riding with me. We are getting to the end of our stream today because I have a whole bunch of stuff I've got to do for back to school today. I appreciate you. We will be back on Tuesday. KK asked in the chat, my chat stopped on the other side, Megalina, so we can make a note. We're at 144 in. KK said, what did dance moms do to be put away? To the best of my memory, it was financial, possibly taxes. Teresa Judice is going to be on special forces. with Cody from Sister Wives. I saw that Special Forces has like pairs. It's Teresa and Gia and Sean Johnson and her husband. It's like you get to go in with a buddy, which is interesting. I enjoy Special Forces. I enjoy Traitors. So we'll see. Oh, there it goes. There was a little bit of a cache, it seemed. So we did a great stress test of the new system today. Thank you so much for riding with us. We're going to make some changes on our end. I'm going to record the podcast. For those of you asking, Emily, when are you going to record it? I do not know yet. Honestly, there's some things I need to finish researching. Tuesday, we will be back. We are not going to be covering jury selection in the Adelson case Tuesday because it's not going to be televised. And then we're going to be on trial watch because the Adelson judge is like, the second we have 12 plus 3 jurors and alternates, we're rolling. So we are going to be on jury watch. We are going to, we're going to be on opening statements watch, I suppose. We are going to be waiting because once they have a jury, they're going to do opening statements and get rolling. So sometimes next week, we will probably be in trial, which means it is time for me to remind you to get the Lawnard app, because the Lawnard app is where I'm going to keep you posted. Once we hear that court is going live, we are going to go live and watch the Adelson trial together. We're going to do our best to not have spoilers, but there are like 4 other trials, and I'm going to record a background of this case for y'all so we have a background on it before trial starts to the best of my ability, because things shifted around a little bit. It seemed that they were going to start on the 25th, and now the court's like, the second we're done with jury, we're starting, but we'll give you a road so far on it. So get your snacks ready. We're going to go to Florida sometime next week. And then Monday, or Tuesday, rather, we're going to try to wrap up all the things that we haven't wrapped up yet. And we're going to do some zhuzhing on our end and get ready for another trial. A number of you just asked, how long is the Adelson trial? It's going to be at most about 2 weeks. The prosecution said maybe 6 days for their case. The defense said maybe 6 days for their case. So 12 to 14 days, give or take. So that actually with court time and Labor Day, it's probably about maybe 3 calendar weeks, but I think it'll be less than that. I think it'll go faster than they anticipate. So with all of that, Law Nerds, it is time for me to roll the outro and get ready for Court Chronic Shocks. That's short. It will be a pretty quick case. Also, they tried Catherine M. twice. They tried either one of the shooters once, one pled, and then they tried Charlie. So they've done this trial like 4 times. So this is trial number 5. The prosecution kind of knows what's coming and how long things are going to take. And then the defense has all those trial transcripts, so they have a good estimate too. So because there's been so many trials that have come before, it's easier for them to navigate. And of course, every trial is different. The evidence to each defendant is different. Their roles in it's different. But it is definitely going to be somewhat media heavy because they've got wiretaps and jail calls and things like that. So I'm really excited about the new setup because all of you have shared that the audio is so much better. So we're going to get to do a new trial with our new stuff. New toys. Emily, follow the dopamine. Law Nerds, it's great to see you. Have a good day. Take care of yourself. I'm going to roll the outro. We're going to get rolling, and I will see you. Well, I'll see you in the app, and then I'll see you on Tuesday. Bye, guys. Thank you for joining me. Make sure you don't miss a live stream or any of the updates on the cases that you care about most with the Law Nerd app at lawnerdapp.com. It's a free download on iOS and Android, so I can keep you in the loop because you never know when something's going to pop off. Thanks for being here, and thanks for being a Law Nerd.